hope we don't have too much of a disagreement here. We
Is he still here?
Oh, I think Brian dropped off. Can you guys hear me okay?
Yeah,
Yes.
I think he's joining
Yeah,
us again.
come on over.
Hey, Judge, I apologize.
It's okay, that happens.
So here's kind of the quick trip. We've made some proposals for a trial date,
Okay,
and we'd like to go to trial. What we proposed, I think, was September of 2024. The biggest point, I think, of disagreement is that they want to go to trial. They had initially proposed a date that was way later. We got a proposed scheduling order they filed on Friday that had a December date. So two issues. One, we'd like to go to trial earlier, and we would like by default to have the deadlines in your traditional scheduling order. Like some of the deadlines they've got in there, it's like 200 days before trial, fact witness discovery closes, 200 days for trial, we designate experts. We don't mind finishing things fast, but we don't want to go to trial 7 or 8 months after everything's done. So that's just kind of the rub of it, is we want an earlier trial setting and we want the default deadlines that you typically use. That's it.
okay. Response?
Your Honor, it's Michael Zellers. Good morning. The primary difference, defendants have proposed a trial date about 2.5 months later than is in the plaintiff's proposal. So the defendant's trial date is December 3rd of 2024. The primary reason for that is we believe that there is going to be more time needed for expert discovery than what's allowed for in plaintiff's proposal. So in plaintiff's proposal, there's 15 days between the opening expert reports and responsive expert reports. Defendant's proposal expands that to 30 days. And then the second difference is that plaintiff's proposal allows for 28 days for all expert discovery to be completed. Defendant's proposal expands that to 60 days. We do think that there are going to be a number of experts here, and it's going to take longer than 28 days to review the rebuttal reports, get the experts scheduled for deposition, and to do the depositions. So that's the difference in terms of length of time that the parties have proposed to trial. There are a couple of other differences between the proposals. Would you like me to briefly state what those are?
Sure.
In terms of depositions per side, there are a number of witnesses and potential witnesses. This case involves, potentially hundreds of oil and gas transactions with multiple parties. But if you look at either the plaintiff disclosures or the defendant's disclosures, there's many, many, many potential fact witnesses. So the defendants have proposed 120 hours of deposition per side. Plaintiffs have proposed 60 hours. And then the other two differences, one is mediation. Defendants believe that for there to be an effective, meaningful mediation, we should do that after expert discovery is completed, which is why defendants' proposal states that the mediation should occur within 15 months of the commencement of the case, and plaintiff's proposal is within 9 months. The only other difference, Your Honor, between the two proposals is that defendants have broadened out by 15 days the time for the parties to exchange pretrial materials between themselves. It'd be very difficult in this case to review all of the deposition designations, all of the exhibits, all of the demonstratives, make objections, and do all that in 7 days. So the defendant's proposal has broadened that out by 15 days. And it also makes a provision for the designation of counter trial deposition designations. So I'm happy to answer any questions, but those are the differences between the proposals. I agree with Mr. Loughton. We're not that far apart in terms of dates, but those are what both parties have proposed.
Okay, Mr. Lawton.
Yeah, Judge, I mean, what we've provided is your standard default scheduling order on deadlines that we're particularly used to. And I just don't think it makes sense to have a trial date farther out with deadlines farther up. If we want to get ready quicker, I'm happy to do that. But I don't want to get a case ready for trial and sit around for 8 months to go try it because we've already finished everything. That's my biggest concern. It's just it's unwieldy. I don't know why we would complete fact witness discovery 8 months before trial. And we don't want to go to trial on Thanksgiving if we can avoid it. I think their trial settings the week after. So that's kind of our beef. We would just ask you to set it at a reasonable date for trial and then just use your default deadlines. I'll work with them on deposition time. That's not a big deal.
So how long do you guys anticipate this case would take to try? I know it's kind of early.
I'm not sure how many witnesses we would need to call a trial, Judge, but I hope it's not more than 2 weeks.
Your Honor, Michael Zellers, again, for the defendants. I would think it's certainly possible it could be 3 to 4 weeks, but I agree with Mr. Loughton. We need to do the discovery and see where we're at in terms of the number of transactions that are at issue.
Well, given that you say it's 3 to 4 weeks, I'm going to probably set it a little bit earlier. I don't want to set it a case that long around the holidays. So we'll shoot for, how about, we're pretty open at this point, that far out. So how about, October 1st? How does that sound? We're
Good.
pretty open, as you can see. So anytime, I'd say anytime in October would work. So what, do y'all have any preferences?
Well, Your Honor, defendants would request later in October, just so that we can work with Mr. Loughton to try to make sure we can get this expert discovery done. We don't mind at all working with plaintiff in terms of fact discovery, because I agree that the more time we can allow for that, the better. Our primary concern is just with experts and being able to get that done.
October 1 works for us, Judge.
Your Honor, defendants would request October 29th, if that's available.
Let's do October 15th, and we'll do the standard deadlines that we have in my normal scheduling order. Let's go ahead and also pick a mediator. Who do you guys want to use?
Judge, we provided 3 names, Mark Whittington, Glenn Ashworth, and Harlan Martin. They've provided 2 different names. It's nobody that I'm familiar with, although I think one of them's a Jan's. Rob Voiles, who I'm not familiar with, and then there's someone named Hesha Abrams, who I'm not familiar with, but we provided a list of 3.
Okay. I'm not familiar with that first name from the defendants. I know Hesha Abrams. All right. What we're going to do is I'm going to give you guys 3 choices. You can each veto one. Hesha Abrams, Mark Whittington, or Chris Noland. And Mr. Lawton, you'll veto first.
Hesha.
Mr. Zellers, you'll veto second.
But Your Honor, I'll defer to Mr. Stain.
Mr. Stain, you'll veto.
Judge, will you please remind me of the third name?
Chris Noland.
That'll be our veto, Mr. Nolan.
Okay, so you want to go with Mark Whittington?
Yes, Your Honor.
Okay. All right, mediator's gonna be Mark Whittington. Anything else we need to chat about?
No, sir.
No, Your Honor. Thank you for your time.
Rhonda, go ahead and put this, did you hear that? We're gonna set this on October 15th of 2024. And we're going to have Mark Whittington as the mediator.
Got it.
All right, guys, you guys have a
Thank-
great rest of your day. And if you need anything from me, just let me know.
Thank
Thanks,
you, Judge.
Judge.
Have a great day.
Thank you, Your Honor.
Okay. Our next case is, we have a TRO. All right, is everyone here on Mendoza versus Great Brothers Electric LLC?
Yes, Your Honor. Jennifer Reinell here for the plaintiff.
Yes, Your Honor. Julian Acol and Ryan Baker on behalf of Acol Law Firm on here for the defendant.
Okay. Let's go ahead and proceed.
Judge Jennifer Reinell for plaintiff. We're here today solely on the issue of the TRO. This is now the third appearance before the court on this TRO. My client is here as well on the video. You can see Mr. Josue Mendoza on the far right on my screen. Your Honor, we're here based on the irreparable harm, which is ongoing as his brother, Jose Mendoza, has chosen a nearly identical name to their prior company. And as he mentioned on the prior hearing before Your Honor, he thinks he can choose any name he wants. And that's the way he's proceeded. He's willfully chosen a nearly identical name, taken the phone number that they use for their business since 2017, and has started a new company, started contacting the clients, and even since we filed the case, has changed the logo on Yelp, or the main Yelp page that they've had this entire time that has dozens and dozens of reviews for the company. And he's also changed the phone number back to the one he took. And this is even, I believe it was even last week that this happened. And so, Your Honor, basically the whole purpose of the TRO is to preserve the status quo as to the LLC prior to.
Let me ask this. Is there any written documents that I didn't get the impression there was any written documents for this company, the formation of the company, or the bylaws or operating documents or anything?
They're an LLC, but there's no formal operating agreements that we're aware of at this point.
Your Honor, there was a certificate of formation filed, but I believe that's it.
Yes, as I indicated, yes.
Okay, so what gives, I guess, either side, plaintiff or the defendant, the right to take the phone number of the company? Is there some type of written agreement on that?
Not to our knowledge, Your Honor. When Mr. Mendoza, the defendant Mendoza, came to my client and wanted to separate, this is a situation where, parties can't just sort of separate, I guess is the way to do it. When you have an LLC or a partnership, obviously you have to dissolve it and divide the debts, the assets, the clients. And among the assets is the phone number, because it's the phone number that's associated with Great Brother for all these years and with all the clients. And so it's causing massive confusion when clients when they Google Great Brother or Great Brothers, they have already started calling the wrong one. So in our mind, the phone number is an asset of the company. I know Mr. Mendoza mentioned to you on a call that he used it was his personal number before the company, but what it is now, it's an asset of the company because it's the main form of contact with the company.
So did this company ever advertise? Like, did they ever have a website or a phone number on the side of their truck or anything like that?
Yes, that's correct, Your Honor. At a minimum, there's the website, there's the Yelp page that our client has used and has, like I said, dozens of reviews, good reviews.
And it's always used this phone number?
That's correct, Your Honor.
Okay.
And, our argument is that the preserving the status quo means that the defendants don't get to just go off and choose a name that's nearly identical and take the phone number and then solicit the clients, and also the detriment of the original company and to my client.
And what has happened to the original company? Is your client running it, Ms. Ronell, or?
He is, yes, he is currently with the very few remaining clients that are there. After defendant has solicited the largest part of them away, including an over $1 million job in Houston that's ongoing, at least to our understanding of the facts so far. This is not a, it's not a small, we're not asking for the TRO on a monetary basis. It's just that, the goodwill and the reputation and the confusion due to the use of basically their common law trademark is causing confusion and major issues with the goodwill and the reputation of the original company. And, the defendant has admitted that they have not wound it up, that they have not divided everything, even though they may have started doing that. It's not been formally done. And there was never an agreement for the defendant to go off and choose to basically use the same name. That there was never any agreement on that.
All right, response?
Yes, Your Honor. There was an agreement entered in July. Both of these brothers created an LLC, which both of them are 50% equity owners in, and that is itemized in certificate of formation. There was an agreement to wind up the business in July. During that time, the plaintiff would continue operating the business until winding up and all debts, assets were paid off. Furthermore, they were to split both assets. We have this itemized. On file, I have 3 countervailing affidavits. Furthermore, I have text messages and client lists to which my client currently has. The agreement was that the cruise, in which half the cruise went with my client, and then the other half of the cruise went with the plaintiff. Furthermore, the employees were split halfway, including the customers were split halfway. Now, I filed objections to their declaration. In their declaration, they are pursuant to paragraph 5, and it's annotated. It's much easier with the order that I've developed. 5, 10, 11, 14, 15, and 16 are all ripe with basic conclusionary statements, speculation, and lack of personal knowledge. Essentially,
Let's go through the text messages real quick because I want to see what they say.
Yes, Your Honor. Now, I have done a translation with those text messages as well that are attached to the affidavit.
All right, I don't speak.
And which motion is he referring to, Your Honor? I don't believe he noticed any of these motions for hearing today.
I think he's just talking about his response, right?
My response and my motion to strike and objections to declaration. And with objections, I do not believe that I need a notice for a TRO.
It's part of your motion to strike, as far as I can tell, based on your late night filings.
Yes, and I did file these on Friday pursuant to the emergency continuance, which I requested when I finally got my head wrapped around this.
So, Your Honor, if you're looking at the text messages,
Yeah, I'm going to go ahead and share screen that. Give me 1 second. Okay, is this what you're talking about, the text messages?
Yes, sir.
All right.
and I will note that it appears that there's I don't know why it is that way in the very first paragraph that they bolded. So they were drawing attention to it. It says, I'm going to remain active on Big Brother. But if you look at the actual text message a few pages earlier, that shows that he's going to remain active on Great Brother. So I'm not sure why their translation would have changed one of the most critical words. And then they bolded it to draw attention to it. So I'm not sure what the situation was there.
Yes, I'm bolding it because essentially that was a portion of the oral agreement they entered into order to wind this down in July.
And I'm just pointing out
everything that the plaintiff is arguing about happened in July, Your Honor. It's been almost 3 months. And furthermore, they're requesting trademark violations. None of this has ever been registered, requested in any way.
And Your Honor, I was pointing out.
Excuse me, ma'am, I'm responding. And for the elements of trademark, it has to be eligible for protection, a senior user, and the likelihood of confusion. Now, Your Honor, pursuant to United States Laredo, with this, which is a seminal case which I've been utilizing on it, these are generic terms for Big Brother services. even if there is a secondary term, well, even if there is a descriptive meaning, you have to have a secondary meaning, in which they have not proven under their declaration whatsoever. Furthermore, a quick
So
look.
you're jumping ahead. I'm trying to figure out these text messages. So these are the text message you want me to rely on. So it says, I'm going to remain active. So the plaintiff, this is confusing because their names are so similar. The plaintiff says, I'm going to remain active on Big Brother. I think
It should have been Great Brother. That's what I was trying to point out. The translation is
until we
wrong.
conclude everything properly and contracts expire because you are my brother and nothing's going to change you. And then the defendant responds, dear brother, I'm sorry that you are on the way. Also, before it was always the good intention to help. We are brothers and blood never changes. Let's do the necessary park. Everyone has a job. The event was excellent. I love you very much. It is very big for many people. I love you very much. The vision is too big for certain people. I understand it, brother. And then the plaintiff responds, what good is vision, brother? What good is it for a man to win the world and not have peace? I examine myself, and if I want the blessings that God has given us through Great Brother, I assume that's the name of the company, but I need to have peace and work in peace. Blessings are those that bring joy, not sadness, and I feel sad. Okay. And then defendant later says, we can grab money, boy, give Don W payment new up. Okay, tell me how much. 60 to 70,000.
Yes, Your Honor. Now
Okay.
that is the itemized that, and I have in my business records.
Is this
affidavit.
all the text messages you're relying on?
Yes, Your Honor, and there's another one. That 60 and 70 was a division where both brothers got 75,000 deposited into their accounts.
This is the
Separate
only
access.
writing between the two of them in these text messages on these 2 pages.
I believe so, Your Honor, unless, let me look at the affidavit. I think there may be one more. No, I don't believe so, because these are all the exhibits, I think. So
this is what details the split between the company is these text messages.
yes, Your Honor, and oral agreements.
So Mr. Nicole, where does it say that your client gets rights to the phone number?
That's in his affidavit, because also with this, they made an agreement that he would get the phone number and continue on because the customers were managed.
Where does it say that in the text messages?
In the text messages, I do not believe there's a text messages that show that.
Where does it say in the text messages that your client has the right to the website?
My client currently doesn't have access to the website, Your Honor. He's been cut out.
Okay, I guess the Yelp website.
It was the Yelp page. Yes, Your Honor.
And that wasn't the Yelp page that they're asserting, Your Honor, is a new Yelp page for his new business, which they agreed to because pursuant to the countervailing affidavit, basically they were going to split, which they did split, and now they're just waiting on the debts and assets. Furthermore, they've said that
none of that's in the text messages. None of what you're talking about. The discussion of splitting the assets, the discussion of the phone number, the discussion of the website, the discussion of the splitting the clients, none of that's here in the text messages, right?
No, it's not, Your Honor. It is not.
All right, I'm going to go ahead and grant the TRO. Let's figure out what exactly we're going to do for that. So what's the terms of the TRO?
So, Your Honor, based on our proposed order, again, we're super worried about the financial in this case but my client confirmed that Mr. Defendant Mendoza does still have access to the bank account. So the first one was just kind of belt and suspenders, not.
Let me get to the order. When did you file the order? Okay, here it is.
I'm happy to send it again.
No, I got it. Okay. Let's see. This is the first page.
So letter A, as I mentioned, is really belt and suspenders because he does still have access to the bank accounts and my client has not undone that. So we just want to be sure there are no transfers or expenditures on that front. And then the second one is really trying to divert clients away from the original business.
Your Honor, in our countervailing affidavit, we've proven and we've shown with our business that all the clients that currently are obtained from our business side and our client. No
Yeah.
other,
Nothing in the text message about that though, right?
no, there
This
is
is just
not.
basically a he said, she said, or he said thing. All right, so I guess the question I have, really the fundamental issue here is, you know, they both have the right to the company, right? They're both still partners in this company. There is no dissolution. So what keeps the defendant from making distributions, transfers, or expenditures? I mean, the way I see it, at this point, there's two people arguing over how this was supposed to go, but nothing in writing. So right now the company still exists and they're both still partners or shareholders. And so what keeps him from?
Well, I understand where you're going, Your Honor. Basically, the point is that he started this new business with a nearly identical name, and he's off functioning as if he's taking the clients and he's using the phone number. So he's creating his entirely separate business. So he's doing everything to damage the old business, and that's really the problem.
And Your Honor, we're asserting that there was agreement for that, and my client from the affidavit has been cut off completely.
No, he is not. I
Yes,
confirmed this
and
morning. He is not. He has not been.
Another issue we have, Your Honor, is pursuant to the Texas Business Organizational Code, we were not given 90 days notice because they filed this as a derivative suit of the LLC.
And you're
Thus, I have a
obviously
motion to abate on file.
which has also not been set for hearing, but that's the
And
whole
it
point of
hasn't
the
because
TRO.
it was yesterday, but I'm getting my counter petition on file today, Your Honor. So I'd probably be asking for an expedited mediation in this matter and an abatement for 90 days because I think both these brothers need to sit down and just work through it with a mediator.
I do agree with that. That's exactly what I was thinking, is that this needs to go to mediation.
And we're fine with that, Judge.
All right, so let's kind of work through this. So the first section,
So for example, Your Honor, if Mr. Defendant Mendoza hadn't gone off and started a whole new business with the same name and phone number, if he was acting like he was a partner, we wouldn't have any problem not restraining him from making distributions, transfers, all of that from the bank account. But the fact that, he's done all of this stuff willfully to damage the original business, that's the main problem. And that's the reason for A.
And Your Honor, I would just like to draw to the court's attention that it's our assertion there was an agreement, and I have two countervailing affidavits.
Mr. Nicole, I just don't. That may be something I agree with you on the temporary injunction phase. Based on what I've seen, I don't have. You can keep saying that. I don't buy it, and so let's move on to the order. So I'm assuming that this company, I'm treating this as if this company still exists because I think it does. It has not been dissolved. There's nothing in writing that indicates how this is supposed to be split up. I think it does need to go to mediation, and in the interim, we need to go ahead and keep the status quo. And so my question is for A is, does your client still want the ability to, one option would be to restrain both parties from making any distribution, transfers, or other expenditures. Or does your client even want to make distribution, transfers?
Well,
the problem
Your
is
Honor,
that,
my client would like.
Wait, Mr. Nicole, I'm asking Mr. Nicole.
okay.
Your Honor, my client would like access to the documents and such, and I would propose that anything over $300 or incurring any debt over 300, both people via writing, express written consent will agree to that for very big distributions. At least that will get us to a mediation.
I agree. That's a good idea.
And Your Honor, I would say too that, my client shouldn't be restrained from operating the business. He's the only one left operating it. And he doesn't have any control over the defendant's business that he's now taken from the plaintiffs. So, it isn't a situation where, he really hasn't, he's created an entirely new separate operation. That's part of the big problem.
I sympathize with both of you. You're both in a difficult situation in that none of this is in writing. None of this was agreed to properly. And I'm basically going on what's in writing. And so what's in writing is this company still exists. They both have the right to it. And that's how I'm going to treat it. So I'm not sure. I'm just trying to make it as clear as possible. All right. B, I'm going to keep. You can't just take the clients away. C, I'm going to keep. D, I'm going to keep. E, I'm going to say to the company, not to the plaintiff, for E.
And Your Honor, one brief thing on A, is there a way, my client needs to still be able to operate and pay employees and contractors and vendors and all that without.
He needs to work with his brother to get that done.
And if he will not approve the expenses, then my client just can't operate. That's the problem, is that he's already hamstrung my client. And this, because of their lack of agreement. And so requiring them to agree it's going to create more problems, and we're going to end up back in front of the court. I can see how this is going to go.
And I would say, Your Honor, I did respond to that. This is for 14 days. This is just a Band-Aid until you can hear testimony. Because I believe when you do, and at least when it comes to the number, that number has been my client's cell phone number for about 5 years.
Mr. Nicole, I obviously will hear evidence. I don't find that at all persuasive, though, based on what I've heard. Now, I may hear more that changes my mind, but if that's the number that was on the truck, that was the number that on the website and how people contacted, it's the company's number. He may have paid for it, but it's the company's number. So, but we'll deal with that I'm just trying to give you some ammunition, both sides, on how I see this case for mediation. So October 30th, what time do y'all want to do we'll do this at 3 p.m. on October 30th.
We're fine with that, Your Honor.
I have a pretrial set over in Ellis County, Your Honor.
What time?
It's at 10, but it's for a 2-day jury trial I have in November. So
I could set this in person on October 27th, if that's better.
yes, Your Honor, that's fine. I have that day completely open, Your Honor. That would be very helpful to me.
I can rearrange and make that available, Your Honor.
Okay, and then we're going to do that at 10 a.m. that day.
And Your Honor, I will be filing a counter.
Let's finish this up, and then you
Okay.
can tell me all the stuff you're going to file. Okay.
Okay.
All right. So what bond do we want to set on this?
For 14 days, Your Honor, I would request if we're going to keep number C available, if C is going to stay in there, so that he cannot use the current business, I would request a $50,000 bond, because this is residential and commercial. And currently they split a lot of the clients, and one of the clients in which they're alleging the 41,000 was taken, I've sent an affidavit with screenshots that is in there And we have big clients sometimes that come up. Thus, I would request a little higher bond than de minimis.
And Your Honor, we would recommend no more than $1,000 bond.
I'm going to set a $2,500 bond. All right. Anything else on the TRO hearing?
I wanted to clarify, Your Honor. So is my client to contact their client directly regarding expenses, or does all of that have to go through counsel? Because that's going to be a daily, sometimes multiple times a day situation.
Well, I would suggest they just work together. They're brothers and they have each other's cell phones. It's only 1 week.
Adding to this just to make it a little bit clear. So does that help clarify it?
So I guess it could go either way. I mean, if our client is comfortable contacting the defendants directly, then I presume we have your permission to do that, Mr. Nicole.
I mean, I'm not stopping your client from, there's no injunction from free speech contacting my client. I think both of
I
these
mean,
individuals need to-
I agree with Mr. Reinell that generally you would not have the clients speaking to each other, but since they're running a business together, you know, I think they kind of have to, but if you guys want to go through counsel, you can too. I don't have a problem either way.
Okay. And finally, Your Honor, just in regards to C, I would just ask that pursuant to common law trademark on that issue.
I've already ruled on this.
Yes, Your Honor, I
So
understand.
you can bring this up at the injunction hearing.
Yes, sir.
Let's figure out who we're going to use as the mediator on this.
I suggest John Ship. I've had very good workings with him, and he's able to get very complicated matters resolved, especially in both partnerships and LLCs.
I was going to recommend Ken Rubenstein. He's very efficient and actually digs into the details.
And
They're both excellent mediators.
my personal preference with burden mediation is their Rule 11s. I don't like their Rule 11s. I've had to actually appeal them. So
What do you not like about the Rule 11s?
they're not enforceable. It's not a good MSA. It just isn't. I had to appeal one over in Ellis County for fees. So I mean, I like King Pfeiffer. I do like them, but I think John is as expensive as Rubenstein, and he has a very good MSA. And I've had better experience.
What I'm going to do is I'm going to give you guys 3 choices, and you can each veto one, unless you guys want to agree to somebody. It's your last shot. You want to agree to someone, or I'll give you 3 choices.
Do you mind using John?
I am not familiar with him.
He's
Who?
really good.
How do you spell his last name?
John Ship.
How do you spell his last name?
SHI. I believe PP. He's really
Oh,
good.
Ship. Okay.
So this is the choice. Each of you get to veto one. Ken Rubenstein, King Pfeiffer, and John Ship. This right now, you get to veto first.
We'll agree to Mr. Ship
Okay.
based on Mr. Nicole's representation that he's a good mediator.
He's good.
Yeah, he is. I mean, I have no
I think-
problem with him. He's a very good mediator.
Okay, thank you, Judge. And I think, it's in everybody's interest to get this, finished sooner rather than later. So
So the deal is if you can't, if Ship can't do that, you have to mediate. So Rhonda, are you there? Rhonda, are you there? Can you hear me, Rhonda?
Yes.
All right, so go ahead. This case is going to be mediated with John Ship.
Okay.
Or a mediator at Burden Mediations before the temporary injunction hearing.
Okay.
So I just don't know what SHIP's availability is. So that's why I'm Burden has so many mediators. You can find somebody there.
And worst comes to worst, what I usually do now, I mean, I'll just probably create a CSA before a compromise settlement before we go, so we can work off that. Okay,
But just, and if you need to extend the temporary injunction hearing to a different date, let me know and we'll go from there.
and Your Honor, in regard, may I proceed with, I just want to make the court aware. I haven't been able to proof it, but I have a counter on file, which we'll be requesting not a TRO, but injunctive relief. And can we just set that at the same time and hear everything at the same time?
In theory, I have no problem with that, but
Okay.
you have to file it first.
Yes, Your Honor. And essentially, I think one of them already that we're requesting is the access to the document. So, and there's nothing enjoining my client from that. So, okay. Are we set for 20 minutes aside, Your Honor? How do you do your docket?
For the temporary injunction?
Yes, sir.
No, I'm not going to keep, it's not going to be that short.
Okay.
We'll just figure it out. Hopefully you guys will get it settled.
Yes, sir.
Thank you, Judge.
All right.
Thank you, Your Honor.
guys. Anything else?
I think that's it.
All right. Did you get all that, Rhonda?
Yes, Judge, I got it.
Okay. And I've already sent the temporary restraining order to the clerk's office.
Thank you so much, Judge.
All
Thank
right,
you, Your Honor.
guys. You have a great rest of your day.
You
Hey,
too.
you too, Your Honor.
All right. Thanks.
Bye.
Bye. Okay, our next hearing is anyone here on Dallas County Hospital District versus Goldwire?
I am Judge on behalf of Defendant Matthew Brazio, and I do see my opposing counsel here.
Okay,
Yeah, good morning, Your Honor. This is Douglas Turk representing Parkland.
right, okay. Is that everyone? Okay. Tony, let's go on the record on DC 231996 Dallas County Hospital District versus Goldwire. Counsel, make your appearances.
Douglas Turek representing Parkland.
Ashley Tremaine representing Defendant Matthew Brazio.
Okay, let's proceed.
Okay, sorry, I couldn't hear you very well there just for a second, but I think you said let's proceed.
But did Mr. Turek make his announcement? I didn't hear it.
Yes, Your Honor, I did.
Okay. All right, let's go ahead and proceed.
Okay. Your Honor, there's sort of two, what I would call umbrella issues here. You know, one is sort of the procedural question of whether special exceptions are an appropriate vehicle to address these issues I've raised. And then two is sort of more looking to the merits of the special exception arguments. Is there one of those that you are more concerned about that you'd want to hear about first?
Why don't you go in the order you just stated?
Okay, so we had filed special exceptions to the breach of contract claim, basically saying this is an illegal contract. You cannot sustain any type of lawsuit based on an illegal contract. In response, Parkland had argued that's basically a prohibited general demurrer. You're basically saying failure to state a claim. You know, you can't do that in Texas. The special exception should be used only to force an amendment or a clarification of the pleadings. Our response to that is that this is not a general demurrer, because a general demurrer is more in the sense of like a 12b6, where you're saying failure to state a claim. In other words, the factual allegations that you have set out in your petition do not add up to any cognizable legal claim, right? And that's not allowed in Texas court because the preferred remedy would be to just replete it and add the missing information rather than dismissing it. So we don't have a disagreement there. But that's not what we're arguing, because Parkland has set forth all of the elements of a breach of contract claim. So the problem is not that their petition was insufficiently pled or that it doesn't add up to any sort of cognizable legal claim in the sense of a general demurrer. Rather, what we are saying is that the facts set forth in their petition reveal that the contract they are suing on is unlawful. And I've given you some authorities to support that you can use special exceptions as a vehicle to dismiss in that circumstance. And in fact, the Fifth Court of Appeals sitting over Dallas just a month ago upheld the trial court's decision to do that. Where a contract is plainly illegal or unlawful, you can dismiss it on a special exception. And because there isn't any sort of pleading amendment that can cure that problem, that's that rare circumstance.
Mr. Tremaine, can you share screen that most recent case out of the Dallas Court of Appeals?
I'm sorry, I could not hear you, Your Honor.
Could you share screen that most recent case of the Dallas Court of Appeals you just referenced? And
Yes, let me pull it up. Oh, it said host disabled participant screen sharing.
let me try that again.
Okay. Eesh. There we go. Okay. So what I'm showing you right now is our reply brief. And here are the 4 cases that we were looking at for this procedural issue. And this is the one from August 29th, 2023, where the appellate court upheld the trial court's decision to sustain the special exceptions and dismiss the case. And that's the same thing as these other 4 cases. And the reason that that is appropriate in this type of circumstance is because the problem is not one of pleading. It's not about insufficient facts. It's not about failure to state a claim. Instead, it's that the petition itself reveals that it is fundamentally legally flawed. The contract that's being sued on is illegal. And some of these other cases actually address that specific circumstance where the contract is unenforceable and void and illegal, and therefore we're sustaining special exceptions and we're just going to dismiss because there is no factual pleading amendment that could solve that problem. This is not a question of facts missing from the petition. It's just the type of contract that they are suing on, which is set forth on the very beginning of their petition, saying, if you don't work for us for 3 years, you owe us money. That is illegal. There is no pleading amendment that can solve that problem. So that's sort of our position on the sort of procedural vehicle piece of it, is that it's not a general demurrer because we aren't attacking insufficiency of the factual pleadings. And there is case law supporting the ability to dismiss in a situation like this.
Okay, response to that?
Yeah, Your Honor, it's interesting that counsel brought up a Rule 12b-6 because if you look at the special exceptions asserted here, our response and a reply, it pretty much looks exactly like a federal 12b-6 motion to dismiss. It's legal assertions along with factual assertions saying that we have no claim as a matter of law because our contract is illegal. The contract is not before the court. It's not no evidence has been provided around that contract. Certainly not evidence that would be competent for a summary judgment. And so at the end of the day, you're being asked to rule as a matter of law that the contract is illegal without even seeing the whole thing. And in defendant's reply, they refer to 3 paragraphs out of the Parkland petition and say that those by themselves establish as a matter of law that the contract is illegal. And it just establishes that there is a contract, that there will be training, that there will be a work period, and that if the work period is not complied with, there will be damages for the breach of the contract. And there's no case law that says that that's the case. And so the court is being asked to basically take everyone's word for it in the special exception process, rather than go through the more formal summary judgment or even motion to dismiss process, where there would be evidence and information around that contract that would help the court decide whether it was illegal or not. And so that's why this is not a favored remedy. This is not, I mean, if you even look at the citations in the reply that were up on the screen a moment ago, they don't really say that it says where a contract was void and enforceable by virtue of a statute. Well, what statute? What was the nature of the statute that was
Yeah,
governing?
Mr. Tremaine, that's kind of why I'd asked for you to share the actual case, so as opposed to a citation like that, so I've not seen special exceptions used quite like this. I've seen them used in a situation where for example, someone asserted negligent infliction of emotional distress. Supreme Court says that doesn't exist, so you can dismiss them that way. I've not seen it used like this, and so I'm just trying to.
So if you want, I can send the court copies of the cases, or,
Can you not just share screen them?
letter, and I can file that publicly.
Can you
so
just share screen the cases?
Yeah, I mean, I can just give me a second to pull them up. Let's see. Sorry, I'm in the B lane.
That may take you for a second. Let me just take care of the next case real quick, because it should be pretty short.
And I would say too, I mean, just real quickly, I mean, that is the cases that you're describing where it's like there's a clear rule that says this type of, contractor claim is illegal. That's exactly what we're saying. And there are clear rules and statutes that say this type of contract is unlawful.
Yeah, I've never seen anyone use a special exception for contracts. I've seen it for claims. So, but go ahead and look at those, and I'll go to the next case.
Okay. Well, I will.
So let me go ahead and call DC 1717249 Martinez versus El Pisano Northwest Highway Inc. Mr. Raphael, Mr. Payne, are you there?
Yes, Your Honor.
All right. Let's go on the record on DC 1717249 Martinez versus El Pisano Northwest. Counsel, make your appearances.
Michael Paymer, representing defendant El Paisano Northwest Highway Inc.
Jorge Rafael, representing the plaintiff, Elizabeth Martinez.
So let me ask first on this, because I think it kind of governs this hearing. What exactly is the status of the appeal? Is the appeal over, or is it still going on?
No, Your Honor. The Court of Appeals rendered an opinion, and they sustained they affirmed the sanctions and reversed on the rest of the case. So we need a new trial, but they affirmed the sanctions. So
and is that what I saw that, but is that final, Mr. Raphael?
Yes, Your Honor. So we're coming back.
So we need to go ahead and set this for trial. This is the oldest case in my docket, so I was thinking maybe next week or the week after. What do you think?
Your Honor, I'm in a federal criminal trial. We've been going on for 4 weeks, and we got another 2 to 2.5 weeks of testimony. And then I got a vacation letter on file for November 13th, the week before Thanksgiving. So I have not contacted my clients yet because we have not had a trial date yet. But when I spoke to Ms. Pinson, I think I asked her.
You're currently in trial right now?
Yes, sir. Well, Judge Lindsay has given us Mondays off. So we have Mondays off. So yes, I have to be back there 8:45 tomorrow morning. It's a very large criminal case.
And yet, and Your Honor, not only that, just as the plaintiff side, I mean, I've assumed in previous situations, we've been given in a reversal time down the road of a new trial with a new order on scheduling and when everything needs to be produced to each other, since, of course, it's been reversed and it's wholly new again. So.
I mean, all the discovery is done. It should be ready for trial, right?
Well, I do need to update. I mean, my client still is getting treatment. I have to send new medical records and everything, but I haven't heard. Usually we hear from the court on a new date and when we can produce, of course, any extra records that needs to be done.
Okay.
I'm pretty much out in October and November as well, Judge, because again, that depends on what happens with the sentencing if we lose and so forth. So I think October is out and I've got vacations in November. So when I spoke to you, Ms. Pinson, I did ask her for maybe some dates in January, and she did say that it's a pretty old case. So I kind of agree with Mr. Raphael. Is that we do need to refresh our recollection of what happens. I think a week or 2 weeks would be a little too short, if that's okay with the court.
We're going to set this on December 12th. Give you a little bit of time. Rod, did you get that?
Yes, Judge, I did.
May I just make sure? I mean, it is the oldest case. I agree.
Unless you have a special setting that week, I'm setting it December 12th.
Yes, sir. And that actually takes me off another case, so which is a new case. So that's fine.
And then there was also a hearing on a bond, I guess.
Yes, sir. We're asking for the bond to be released. We kind of agreed to it, but I don't think I received the agreed order back from Mr. Raphael, and he did email me this morning saying, do we still need to have a hearing? So I guess the numbers are okay and the court can just sign off on those if Mr. Raphael has no objections.
No objections, Your Honor.
I did file, Your Honor, just so that there's no mistake, I did file an amended motion on Friday after talking to Mr. Raphael and an
Okay.
amended order. So if the court would look at the amended order.
Yeah,
And
I see that. Let me make sure. I'll go ahead and share a screen to make sure it's the right order. Is this the order that you wanted signed?
Yes, Your Honor. I'm just looking at the number, Mr. Raphael. I think that's the number we agreed on.
I believe so, yeah. If
Yes.
that's the new one you filed last week, yes.
Yes, yes.
Okay.
So I guess now we see how it's done, Judge. I think that's the
Yeah.
first time I've seen.
Yep, it's allows me to just send it directly to the clerks.
Right.
It theoretically saves time, so. All right, Ron, did you get the new trial setting?
Yes, Judge, I did, December 12th.
Yeah, in this case is less than a week. We have to get it done within a week, but I don't think that'll be a problem. All right, guys, we'll see you on December 12th. Do you want me to send this back to mediation or not?
I suggested to Mr. Raphael, I think he was on vacation or out of town. I have no objections to mediation, Judge.
I mean, we've mediated before, Your Honor. I mean,
It's up to him.
I could talk to my client. It's up to the court, but I mean, we have mediated, we have gone to trial prior to, and I don't know, but I'm can't hurt. We can try that.
Why don't you guys mediate it with how about Ken Rubenstein?
We can
Well, do you mind, Your Honor, if I'm glad to get with Mr. Payman, see what's available. You know, it's convenient for everyone. We can get something sooner because sometimes Mr. Rubenstein's schedule is hard to get on, and I've had issues with Mr. Rubenstein in the past. Not issues, just previous experiences.
Who do you want to use? I'd rather just get one. Who do you guys want to use then?
Judge Pfeiffer is pretty good. I don't know if Mr. Raphael has had any experience with him.
I've had no experience with Judge Pfeiffer. There's Adam LaCrone. I've had experience with him. Jim Janot, those folks.
How do you feel about those?
Judge, they're both recognized and well-known mediators, so I'm fine with whoever will see us. The time works with us, so.
I know LaCrone is scheduling way out, and I think Janot is too. How about we do Rhonda? Let's do an order on this case. This is the El Pisano case. setting it for mediation prior to trial with Adam LaCrone or anyone at Burden Mediations.
Okay.
LaCrone is a very good mediator, I've heard, but I've heard he's really hard to schedule with as well. So, but you can always get someone at Burden. So, all right, guys, good luck, and
you, Judge.
we'll see you on this. Hopefully not, but hopefully we'll see you on December 12th. And good
Thank
luck
you,
with
Your
your trial, Mr. Pema.
Thank you, sir.
All right, thank
Are
you.
we
guys.
excused?
You are.
Thank you.
All right, let's go back to the other case. I know, Tony, do you need a second to switch files? Are you ready? Switch files.
Yes, Judge, I'm ready. Sorry.
All right. We're going back on the record on Dallas County Hospital District versus Goldwire. So go ahead and share screen. Is this the case?
So I've pulled up all three of them. The most recent one out of the Court of Appeals was actually, it was on a jurisdictional question about whether Abbott had, appropriate discretionary authority or not. And the court did not hear evidence. And oddly enough, I would say this case, this Stansu versus Abbott case, is really a whole lot more like a 12b6 than what ours is, because here they just looked at the face of the petition and they were like, well, sovereign immunity applies, the end. Case dismissed on special exceptions, and then, upheld at the trial court level. But I think we can admit that there are some differences here between Stansu versus Abbott and our particular case, because Stansu versus Abbott is not about a contract. The two cases we cited that are about contracts are this James versus Vernon Calhoun packing, where so they're saying on the face of the petition, the consideration was a waiver of the claim for compensation, and that renders a contract illegal, void, and unenforceable by virtue of this statute. So they grant the special exceptions and dismiss the case.
Give me a second. So stop there for a second.
Yeah, sorry.
So the below correctly sustained special exceptions to appellant's cause of actual breach of contract for lifetime employment because the consideration alleged for said contract was a waiver of appellant's claim for compensation.
I
don't understand that. What were the facts of this case? It sounds kind of bizarre.
So I believe this was statutorily, you can't waive certain like workers' compensation issues, which I believe is the statute that they're saying the contract was in violation of.
Oh, claim for workers' compensation, not for compensation.
Well, it doesn't say that, but yeah. This is a 1972 case, so it's old. And then the other one is kind of similar, and I got to find the exact language, but here in this Heron versus Hollingsworth, they were saying that the contract just on its face violates the Securities Act. So special exceptions, we're going to go ahead and dismiss. Now, I will say too, if the court is disinclined to go as far as a dismissal, then I think, you know what, fine, let Parkland try and amend and rewrite its petition in a way that suddenly makes this lawful, and we'll file a motion for summary judgment on that as soon as it's filed, because the reality is there are no additional facts that can change the fundamental point that this contract is illegal. So we can kind of go through those motions if we need to. It's our position that it's unnecessary, but I can hear the court's hesitancy to take that step. So then we would request that if you do see merit in the underlying issue, that we've identified 4 separate reasons why this contract is illegal, that we would say, all right, then grant the special exceptions and allow Parkland to amend if it believes that amendment can somehow solve this issue. And then we can go through the steps of a traditional summary judgment.
All right, I'm going to order Parkland to amend within 14 days to address the special, I'm going to grant the special exceptions and order Parkland to amend within 14 days.
Your Honor, may I respond real quickly? I know you just entered the order, but I wanted to just show you I didn't get a chance to respond after the break there. Could I just have a couple of minutes?
Sure.
Okay, so can I share my screen, Your Honor, with their reply?
So I do want to say this, Mr. Turek, that if you continue to argue, there is a chance I may agree with her and grant the motion to dismiss. Do you really want to argue this? You kind of got to win here, but we can keep fighting over it if you want.
No, Your Honor, that's fine. Thank you.
All right, let's go ahead and amend this. You have 14 days to amend it. And then at that point, Ms. Tremaine, if you still feel like you want to move for a summary judgment, you can. So go ahead and get me an order on that, Ms. Tremaine. Make sure it says at the beginning that this was heard on October 16th, 2023, not on this date. Share a copy of the order with Mr. Turek and get this order to me by this Thursday, okay?
Will do, Judge. Appreciate it.
All right, you guys have a great rest of your day, okay?
Thank you, Your Honor.
Thank you, guys. All righty. Our next hearing is on the motion to strike. This is the, let's go on the record on, it's not quite time yet. Is everyone here on the Diversitas Holdings LLC versus RDS Just Flowers Inc. case?
Yes, Your Honor. Renee Casas here for the plaintiff, and I believe I see Mr. Silloway on Zoom as well.
Yes, I'm on Zoom.
All right. Is that the defendant?
Yes, Your Honor.
Are we expecting any other defendants?
No, Your Honor.
Mr. Silloway, are you expecting anyone else?
No, sir.
All right, let's go on the record on DC 238295, Diversitas Holdings LLC versus RDS Just Flowers Inc. et al. Counsel, make your appearances.
Renee Casas for the plaintiff, Diversitas Holdings LLC.
Sir, you need to state your name.
Robert Silloway, RDS Just Flowers Inc.
And Mr. Silloway, just so it's clear on the record, are you an attorney?
No, sir, I'm not.
Okay. All right, so you're an individual defendant in this case, right? As well
Yes,
as,
sir.
okay. So Ms. Casas is wanting to strike your answer because for the corporation, under Texas law, a corporation has to be represented by an attorney. So you can represent yourself on your own individual claims against you, Mr. Silloway. If you're not an attorney, you cannot represent the corporation. Do you understand that?
Yes, sir.
So I typically do give people a chance to try to find an attorney. Have you been speaking to attorneys about this?
Yes and no. Everything come up. I mean, long story short, attorney said that I needed to go over an answer, and I answered not really knowing what I'm doing, and he's given me a recommendation of another attorney. My attorney doesn't handle this kind of stuff.
Okay.
So I'm trying. Yes, sir, I am looking for another attorney.
All right, so Ms. Casas, you're gonna need to prepare an order that indicates that this is only directed as to the answer to the corporation. He can represent himself on the individual claim. That if he does not find it, so start off with on this day, October 16th, 2023. No, don't do on this day like a lot of times people do. And then the plaintiff, defendant corporation, Just Flowers or whatever it is, has to file has to have an attorney file an answer within 21 to 28 days. Otherwise, his answer will be struck in the and will be subject to a default judgment. Does that make sense?
Yes, Your Honor. Can you Pete, you said, how many days? They must, get an attorney to file
28
an answer
days.
within 28?
28.
Okay,
So Mr. Stillway, if you want to fight this on behalf of your corporation, you need to get an attorney to file an answer within 28 days.
Yes, sir.
All right, and you need to share a copy of that order with Mr. Stillway and get that filed by this Thursday, okay?
okay, I will do that. Mr. Silloway, I know, I did e-serve you a copy by email of the motion. Is that, does that work for you, the email? Can I
Yes, ma'am.
email
Email
you?
works fine. Email works fine.
And
Okay, I will email you a copy of the order as the judge instructed me to do.
just one
Right,
second.
On
Wait.
this last, go ahead.
I just want to make sure we have a copy of your email address on file.
RustyLugnut@yahoo.com.
We got it. Yep. Okay, anything else, guys?
No, that'll be it, Your Honor. And I e-file it with the court or just email it to your coordinator?
Both.
Okay, will do.
All right, guys, anything else?